All right, good afternoon, Facebook, and welcome to another edition of Real Estate Talk Live. This is Tony Martinez, broker of the Extreme Realty Team Companies, joined by my co-host Omar Arcia of the Arcia Law Group. So, listen, this is our third installment, and I think we're getting better as we go along. Let's at least tell ourselves that, right? Just to make ourselves feel better. But the show is constantly evolving. I mean, the first time we did it, we said, hey, let's call it Ask Our Lawyer. And then look how fancy we are now. We have Real Estate Talk Live.
That's it,
we have our own logo and all this stuff like that. But listen, I'm enjoying it. I think you are as well. I don't think there's another show like it out there where our target audience is a mix of the real estate professional and also the consumer. And so we're broadening our reach now so that it can take on several different segments, including real estate updates and news and trends. But we always want to take care of our core group, which are real estate professionals, and be a resource for them to help build their businesses. So part of what I want to talk about today a little bit is some of the common mistakes that I see real estate agents making that's holding them back in building their businesses. But I'm going to let you start off with a couple things first while I log on and see if there are any questions. Again, this is a very interactive show, so any questions that you have, go ahead and type it in. And also help us spread the word. If you're watching the show now, go ahead and hit share it to your timeline, and then all of your friends can go ahead and continue to build our audience. So think of some questions. We want to get to as many, if not all of them, before the end of the show. It's an hour-long segment which flies by.
Absolutely.
But earlier we were talking about contracts, and I see agents, and it's sad, but agents can be pitiful at the contracts.
Well, what happens, just like anything else, Tony, is that agents become very complacent with the level of knowledge that they gained 5, 6, 7, 10 years ago, and they're not up to speed on everything that's happening with real estate law and changes in contracts and that sort of thing. So the number one mistake that I always tell folks that they're making is they're not being proactive enough in learning the changes to contracts and real estate law. Guys, there's so many different shows and so many different seminars that you can attend that most of the time are offered for free, where you're going to get invaluable information and invaluable experience from the presenters. Most of them are either attorneys, brokers, people with tremendous experience in the real estate industry that are there to share their information and to share the experience that they have. So I think that it's imperative upon all the folks that are watching. I think it's great that we have this awesome audience of real estate professionals. It's a very unique situation, right? Because most of the time we're speaking to either consumers or we're speaking to other folks. I'm mostly speaking to attorneys, but but it's great. It's great that we have licensed real estate professionals that we can talk to on a one-on-one basis through this awesome format, and then share with them what we believe can make them better at their trade.
Yeah, because it's heartbreaking. It's a difficult enough business, and again, today I want to touch on some ways that they can build their business. But it's a shame to get to the point of an offer, a contract, and then have things fall apart or things go wrong because there were things that were missed. And unfortunately, one of the common trends within the industry is that more and more real estate professionals have less and less support from the brokerages that they've associated themselves with. So they really are. I call the agents, those agents, they belong to On Your Own Realty, because they really are on their own. And it's a shame because we're dealing with people's lives here. We're dealing with the largest investment that most people are ever going to make.
That's correct.
And we're in a highly litigious society. The minute you get a real estate license, a huge target goes on your back. So many of these things could be avoided if we just took the time to understand exactly what we're doing. And so that's why we talk about contracts so much, is because where the rubber hits the road, what's in that contract or what's not in that contract is going to determine the outcome, right?
Right. And you would think that some of these larger agencies, real estate agencies, would give their personnel and their agents unlimited resources and unlimited training. But the problem is, the larger the agency becomes, the harder it is to get that personalized service from the people that matter and the people that can provide you with information. That's why I really enjoy working with Extreme, because it's not just a matter of you just bring in agents and flush them out, bring them in, get them as many commissions as possible. I think your team really genuinely cares about making sure that the people out there wearing an Extreme tag and handing out an Extreme business card really know their craft, really know what they're doing. That's why you do the regular trainings here. That's why we're doing this program.
Yeah, absolutely.
Because we want to make sure that these folks are aware of all the choices that they have as real estate brokers. And the number one thing they need to be aware of, what makes them stand out from the rest, is how well you can represent that client.
Agreed. Agreed. When we decided to do this show, we figured our primary audience are our own sales professionals, and anyone else that's watching is a bonus.
Right.
We could have easily kept this to ourselves, but you're such a valuable resource as our legal counsel. We figured, why not make it available to the industry? So here's a scenario that just came up, and I believe that we're completely in the right here, but I want to get your take on this. So using the older as-is contract, we're representing the buyer, and the buyer was not able to get the loan approved. So the buyer, within the loan commitment period, which was a default 45 days, communicated to the seller's side, the seller's agent, that look, it was not approved, we're not going to be able to get it. And one of the things I always teach my agents, taught, because it doesn't apply now, you had to have at least a 7-day window between the end of the loan commitment and the closing period, in order for unless there's any other defaults, for the buyer to be able to get their deposit back.
That's correct, yeah.
Okay, so this is ingrained in their heads, and I can't tell you how many people don't have no clue that provision was in there. So if your loan commitment date was a Monday, right, and the deadline was a Monday, and you were closing Friday, and you didn't get it, you weren't getting your deposit back.
You're not getting a deposit because the old contract required that you notify at least 7 days prior to closing. That's what the contract says, or the old contract says.
The old contract. So in our situation, it was right there at the 7 days, and the seller is being difficult and not wanting to release the deposit, and I've assured my agent, look, your buyer is 100% in the right under these circumstances, and if need be, we'll bring in the big guns.
Well, I mean, that's what happens. And let me tell you something, I mean, a lot of times when those disputes arise between either different brokers or brokers and their buyers and their clients, what the differentiating factor is the moment an attorney gets involved and provides an opinion letter and sends a demand letter and says this is what's going to happen and this is why your position is wrong on this. All of a sudden, it's like the sky opens up and everything gets resolved.
Absolutely.
Because no one wants to be involved in litigation.
Yeah, and
that's what it boils down to.
So that's a conversation for after the show.
Yeah.
But absolutely. I know our agent is watching. I'm sure he feels much, much better hearing that. Would you agree with this, that one of the reasons why we have so many problems with contracts is time is of the essence. Mm-hmm. And we have to begin with a common understanding of what our effective date is. And so often what we find is because, technology has hurt and has helped us. Back in the day, you went and you met with an offer, you sat down, you were face to face, people signed it on the spot. It was 100% in agreement as to what was your effective date going forward, right? But a lot of agents, even agents, don't understand that it's always been, because you ask an agent, hey, so when is the effective date? The date the last person signed or initial, and then they forget the part that says, and it's delivered.
Right.
So I think agents, you want to avoid a lot of problems in the future, have a complete understanding with both sides as to what the effective date is, because all timelines begin from there.
Exactly, and that terminology in the standards provision of the regular as-is contract, I think it's paragraph 18V or something like that. It says time is of the essence for a reason. Mm-hmm. It means that you have to abide by deadlines.
Yep.
And if those deadlines are not abided by or they're not followed, then you have the right to proceed against the other party. That's what it boils down to. We have a seminar coming up that New World is sponsoring this Friday up in Delray. And you can certainly, we can send out information on your website.
We'll put it on both of our pages. You got to go to that. You're a real estate agent, especially with the new changes, with the as-is being taught by Omar himself. You got to go to that class.
We're also doing another seminar next week on Tuesday at the Wines and More on Pines Boulevard. They have like a presentation facility next door, and we're filling that up pretty good. We're getting about like 55 people right now. That are scheduled to come, and hopefully we'll have some more. But the idea is I'm going to be presenting a very detailed explanation and comparison, not only of the new as is, but also of the as is contract and the crisp contract.
Okay.
So you can kind of have a differentiation, because people don't know that there's differences between those two, and there's huge differences.
Yeah, business days versus
Actual days.
Actual days. That's huge.
Yeah. So, but both contracts say that time is of the essence, and we need to abide by that, and we need to be aware of it. And if you have any questions, especially if you're an agent of Extreme, all you got to do is send me an email or contact Tony, and he'll contact me. Any questions at all about the contract or its enforceability, or whether you can get your client's security deposit back, or whether you can proceed with the contract, whether you can force a closing on the contract through specific performance. All of these are issues that come up, and you need to be vigilant when these issues come up as a broker and as an agent, because you need to say, okay, wait a second, I'm now 100% sure as to how I should advise my client. And one of the things I can tell you they teach us in law school, and I've learned in 23 years of practice, is you never, ever advise a client unless you know exactly what you're talking about. You don't want to shoot from the hip, because the perfect response to a lot of clients, because listen, I've been stumped by plenty of clients. I'll say, listen, that's a great question. I need to look that up. I need to do my research, and then I'll get back to them, and I'll provide them with an intelligent, detailed response. I don't believe in shooting from the hip. I want to make sure that clients know exactly what they're getting.
No, agreed. And we have another great question here. And, we were talking about this theme a little earlier, and that is within our real estate community, there are agents that have multiple designations, multiple careers. An agent might be a professional home inspector, or an agent might be an attorney, and it's also an agent. And the lines can get blurred when you're out there, because in one scenario on the surface it seems like that could be a huge advantage in their marketing, right? Hey, listen, why would you list with me? Because I'm not just a regular real estate agent, I'm also an attorney. On the surface that sounds like, wow, I'm getting 2 for 1, but they're not really getting 2 for 1, because they're acting on behalf of that person as a real estate agent unless they've been hired as an attorney. So expand on that, if you would, please. How an agent should protect themselves, and the consumer needs to be protected as well.
Listen, I think it's great that you have realtors out there that are also multi-disciplined professionals, where the realtor can be an accountant, the realtor can be an attorney, the realtor can be a licensed home inspector, it could be a licensed adjuster. That's great that they have those other disciplines, and you can market those disciplines. You talk a lot about in your seminars about kind of standing out from the rest of the agent, from the rest of the crowd, and that's a great way to stand out, because a lot of people that have these multi-disciplines don't do anything to market themselves with that multidiscipline, because they feel that it's inappropriate, that it's deceitful or anything. No, absolutely true. I mean, you can market yourself with any truthful statement regarding what you've accomplished, what you've done, or what you are. If you have licenses in other disciplines, you can market that. Now, when the client hires you, because you've got 2 different sets of people. You've got the prospective client that's out there that you're marketing to, and then you have an actual client that now has established a client-agent relationship with you. The moment the client establishes a client-agent relationship with you, you need to make it clear to that client, if you have multidiscipline licenses, that you are wearing your realtor hat and none other.
And how should they do that? In some form of a disclaimer, hold harmless, something in writing?
Right. Well, what I've kind of created, and I want to encourage all your agents and anyone watching this to do right now, is to reach out to us, because I've created an addendum that you can attach to your agent-client agreement, or to your listing agreement, that specifically disclaims any liability or any claim for anything you may have said that may have given that person the inclination or the suggestion that you were giving legal advice or advice regarding property appraiser or property adjustment or property inspection. Obviously, as a property inspector, for example, you walk into a home, you're going to see certain things that as a layperson, we're not going to see. And the regular agent is not going to see. You have an ethical responsibility to advise your client that. But does that mean that that client can now hold you liable for that? not if you signed a disclaimer. If you're just advising that client and that client believes you're providing advice, whether legal advice, accounting advice, home inspection advice, now they've got some other angles that they can come after you if that transaction goes south.
That's wonderful. So with this, we have a couple other questions, and I love how the questions typically center around what happens when someone decides to flake out at the last minute. Is that a legal term, flaking out?
I don't think that's in the Black's Law Dictionary.
It should be. It should be. Just we're going to go back to the questions, but I wanted to jump in and share some insights because I feel for what real estate agents go through. This is a very difficult business. I don't think that's properly conveyed when people are excited and they're getting their real estate licenses. And what I always say in my classes is, when you got that notice in front of you that said pass, there was that moment where you went, really? Okay, is this mine? Okay, then you think, let me get out of here quickly before they change their mind. Right, and then you go out and you grab your phone, and the first person you call is either your significant other and or your parents, right? And you don't get on the phone and say, guess what? I passed. I can't wait to fail.
Yeah.
I don't think that's part of
I don't think I've ever heard
that part. But you know what? Sadly, 80, maybe as many as 85% of real estate professionals, new ones, don't make it. And I always tell people, you have a year, and this is why. They need to join the board, or at least if the real estate company is doing business the right way, the agent must join the board of realtors. So they pay their fee, they pay for a year, now the clock is ticking. Now they have 1 year to make some money to justify their existence, to go ahead and keep their spouse from nagging them all day long saying, when are you going to get a real job and all these things, right? And so what are the common things that hold people back? And we can do an entire segment on this, entire show on this, but just very, very quickly, I would say, one, it really does begin with the choice of brokers. Now, of course, I'm biased. I don't do this show for my health. Right. Obviously, praise God, this is a democratic country. This is a capitalistic country. Both of us are from Cuba, so we know what the other side's all about. So, but we believe that we're providing a value, and in exchange for the value, the fact that we're saying, hey, by the way, if you have need of these services, we like to be someone you consider. Sure. But I've just seen so many agents just get so blinded by the split. It's all about how much can you pay me? And I gotta tell you, I interview new agents all the time, and when I ask them what's the most important thing to you, if the conversation starts with, well, the split, usually I cut that meeting short. Sure. Because I want agents to say, you know what's important to me? Training. What's important to me is support. So if you're out there and you're struggling, first look in the mirror. Look in the mirror and say, are you really doing everything you're supposed to? Because it's so easy to blame the broker.
Sure, absolutely. You're going to look to the first person that's around you, and usually the broker is that first person. They're not doing what they're supposed to be doing, so the finger's going to get pointed at them.
Right.
But I absolutely agree with you that the first thing they need to look at is look in the mirror. Are they doing everything to make themselves as valuable as they possibly can to their clients? Yeah. And having multi-disciplines and doing other things and standing out with other practices is what makes you valuable to clients.
Yeah, when you're first starting out, the reality is you go through school. If you could even spell real estate when you leave school, that's a great thing. But now you get onto the contracts and the business building. What are the suggestions I have besides, number one is, choose wisely, because not all brokers are created equally, okay? Secondly is look for a specialization. The last thing this industry needs more of right now are more general practitioners. Right. And that's what schools turn out. Every time you get your real estate license, here we go, here's another general practitioner. What do you specialize in? Nothing. What do you do? Everything. They do everything but specialize in nothing. And I go, why don't you pick a niche or two? An example, short sales. I call short sales the low-hanging fruit because so many agents ignore them. Well, why don't you be the one that says, I want to pick some of that fruit? Another class I'm really proud to be associated with, which I teach, is the military residential specialist, which we teach agents how to effectively market their services to veterans and active military. That's a huge niche.
It's a completely ignored market by a lot of agents.
Because agents are scared. Yeah. The confused mind, I give a shout out to my friend Fred Lenosa, he taught me this, he says the confused mind says no. And when you go to a typical real estate agent, you say, I'm interested in buying a house using a VA loan. Oh, no, you don't want to do that because no one's ever going to take your program. And consequently, fewer than 11% of veterans that are eligible use the VA loan program to buy a home. Yeah. So that's an excellent area that you can specialize in. You can specialize in first-time buyers. You can specialize in retirees. but pick a niche or two that you can go ahead and crystallize your training in that area. Okay, and last but not least, at the end, treat it like a business. You know, a lot of agents don't come from a business background. They were in a mentality where they were an employee mentality. So they were used to showing up to work at a certain time and someone saying, do this, do this, do this. Now you're in real estate, you're your own boss.
Yeah, they're used to putting in the 9 to 5, and now all of a sudden that 9 to 5 became whenever to whenever.
Whenever, yeah.
Right? Saturdays and Sundays sometimes, whenever the client is calling you, whenever you need to go there. And you know, that kind of rolls into something that I firmly believe is, and we've talked about this, you have to be passionate about what you do. Whether it's being an attorney or being a real estate broker or being a cyclist, whatever, you need to be passionate about what you do in order to do it well. And when you say you got to give it that 1 year, listen, if within that 1 year you don't see that that's a passion for you in doing what you're doing, whether it be a real estate broker or being an attorney or whatever, you need to kind of do some soul searching and figure out whether that's what
it's not for everyone.
No, it's not.
But you know what? A segment that I really feel for are part-timers. You know, not every real estate company is part-timer friendly. We at Extreme are part-timer friendly. So what does that mean? Number one is, do you allow part-timers to come to work for you? Of course we do. And there are companies out there that truly don't or discourage them. Some of our best stars started as part-timers. When I look at someone, I look at what their dreams are, what their why is, not what their current situation is, right? But the reality is that when you're not available, and there's part-time and there's part-time, if you're a person working 8 to 5 every day, that's going to make training difficult. It's going to make a lot of things difficult. So you're going to have to work harder. You got to work twice as hard, but you also have to be in an environment where there are other options for training. I mean, I pride myself on offering evening trainings, which is unheard of. But those are the things. I mean, and if you're going to be part-timer in the business, here's an excellent tip, okay? See if your company offers a transaction coordinator as part of their services, because when things go wrong with contracts, oftentimes our deadline's not met, right? And if you're a part-timer and you're working 8 to 5 someplace else, what happens if your mind is and you're missing a deadline? Well, when you have a transaction coordinator, that's a second set of eyes out there and helping you during the day for all these kind of scenarios. So there are people that do this for a living and they charge anywhere from $300 to $400 a file. One of the things I'm proud of at Extreme is we make that available to our agents at no additional cost.
That's great.
So, because again, it's heartbreaking to work that hard and get to that point and not get paid.
Yeah, it's important. And we talked about missing deadlines and making sure that we make our appointments and that sort of thing. And that's really what makes or breaks a real estate broker. I mean, it's basically making sure that you can come through on what you promise to your clients, that you're there. I mean, we work with a lot of agents in short sales transactions that we're involved with and in other transactions that we do closings on. And the ones that we can rely upon and we can turn to are the ones that have the most level of organization. And a lot of these people that are coming from another discipline or another practice or another 9 to 5 job, they just don't have the level of organization. And in those kind of circumstances, I would really encourage those people to kind of shadow other people that are already at a different level, so that they can kind of feed off of that like a sponge what they need to be doing to ensure that they're not missing deadlines, that they're attending to their clients in the right way, that they're maximizing the use of their time. Because we see a lot of agents that they'll come in to the office or they'll come into wherever they're, or even set up a home office, and they just don't maximize the use of their time. They're kind of running in place and not really doing anything to generate any new leads or bring any of their deals getting closer to close.
So here's a contract question. This comes up a lot. It's the day of closing. One side or the other decides on the day of closing they're not going forward with it. Okay, so wear both hats. Wear the hat of the buyer and wear the hat, because that's probably one of the ultimate and heartbreaking situations. You feel for the seller, because one of the things I've always felt that's inherently unfair with our system here in Florida is that the seller must be out of the property the day of closing. The day of closing belongs to the buyer. So here you are on the assumption that you're going to close and going to be paid. You've completely disrupted your life. You've gone on with your life. You have to move. Then you get to the closing table. Buyer decides, I changed my mind. Conversely, you could have a scenario, and we do, where buyers got the truck in the parking lot. Okay, they're ready to move in. Hey, day of closing, house is mine. I'm moving in.
Seller says no.
Seller says no. So, my man, tell the audience what options exist. And I know that you want to try to get both parties to try to whatever, but aside from the common sense approach, what legal rights or remedies, if any, exist?
We're going to operate under the as-is 5, right? Okay, under the as-is 5, what we see from both the seller and the buyer in terms of the rights is pretty straightforward. I mean, you can spin it 20 different directions, but it boils down to a very simple thing. The seller has to, if the buyer has financing, if everything's ready to go, if the seller has not backed out of the deal within the terms of the contract, and the seller, if there's marketable title that the seller can provide, unless the seller cannot provide marketable title at the time of closing, the seller must go through with that transaction. So what remedy does the buyer have if the seller says, you know what, I've had seller's remorse, I don't want to go forward with this transaction? Okay, so the buyer at that point, you know, you're in all the way, your security deposit is in, you have two options. You can either agree to terminate the deal, get your security deposit back, everyone goes home, if you will. Or if the buyer wants to press the issue and wants to get the closing done, then you have two options. According to the as-is 5, you have to request a mediation with the seller, and you have to make a demand to say, listen, I want to close on this deal. I want to go forward with a mediation for specific performance, which means that you're requiring the seller to go through with the deal. If that mediation fails, then the buyer can sue for specific performance in court. That's under the as-is 5. If we're talking under the CRIS contract, they would have to file an arbitration to enforce specific performance. But I mean, now from the buyer's side, okay, if the buyer at the closing says, you know what, I decided not to go forward, that one's a little clear. I mean, basically the seller at that point says, you know what, I'll just take the deposit and you go home. That's it. And make a claim on the deposit. I mean, unless the buyer has some legitimate grounds to cancel that transaction. And at that, if you're at closing already and you've already gone through your inspection period, you've got financing or there's no financing contingency, you're ready to close. You need to close. If you don't close, then you're going to lose that security deposit.
So, if I'm hearing you correctly, it's not going to be settled that day. More than likely, it's not going to be settled that day. So that's the first thing that we have to recognize is that, of course, these scenarios happen, and many times we're able to get the parties on the phone and we're able to say, hey, what's going on? Do you understand what this means? Do you understand what potential liability you're exposing yourself to? Sometimes good real estate agents working together, we can go ahead and bring the parties back to the table. But if it doesn't look like that's going to happen, well, at that point, it's about mediation on the as-is, and mediation doesn't go ahead and work, then it can go into...
Then the seller can file a separate lawsuit. I'm defending a case on that very same issue right now where the seller realized just a couple of days before closing he was not going to net anywhere near what he thought he was going to net at the time of closing. And so he just decided not to go to the closing. And, you know, bottom line is, you know, obviously he comes to me afterwards.
That's not a good reason.
And you got to tell him, listen, this is the situation. You didn't go to closing. Now you're exposing yourself to this situation. But the good thing in that case is that the buyer, instead of going through the mediation process as required by the contract, immediately went to litigation, filed a lawsuit right away, which means that I can go in there and stop that lawsuit right away, force a mediation, and hopefully during the mediation we can come to some kind of an agreement as to either proceed at a higher price or do something that will allow the transaction. I'm always pro-transaction. I always want the transaction to go forward. That's my goal in every one of these deals. And the brokers listening to me out there, I want your transaction to go forward. I want everyone to walk away from the transaction feeling like they had a successful event out of the transaction. I don't want them to feel like this was World War III, and now we got to get all kinds of attorneys involved, we got to lawyer up, and we got to... No, I mean, real estate transactions should go smoothly as possible, and if there's any issues, and frankly, in that particular case that I was talking to you about, that could have been resolved several weeks before, when the seller receives the communication indicating to them how much they're going to net from the transaction.
Right.
And at that point, you can start talking to the other side and say, listen, can we do something so that maybe I can, walk away with $5,000 more, because right now I'm paying to close on this transaction.
Yeah, on the surface, again, not having all the information, but that obviously on the surface it appears that there is a definite lack of communication between the seller and the listing agent, because the two things that a seller is concerned about when they're meeting with you in a listing appointment is how much do you think I can get for my property and how much am I walking away with. Those are the two things that they're very, very concerned with. So that figure is important.
100%.
It's important. So those things can be avoided. So real estate agents, what I would say is whichever side you represent, communication is key. You have to be talking to the party you represent at least once a week and make sure that their motivation is still there. You want buyers to be picking out drapes. You want buyers to be requesting access to measure the room so that they already have the furniture lined up. That's a motivated buyer. You want your buyer to be responding to lender requests for documentation yesterday. That mentality there. Now, from a seller's perspective, you don't want a seller that isn't even packing, and is drawing close. Come on, there's a red flag there. Why is it that you're only a week or two away from closing and there's no packing going on?
Right. There's no indication that they're ready to move on.
Right.
And a lot of these sellers that don't have any inclination of moving on. I mean, I can tell you that I've been through some of these transactions where the sellers are kind of going through the motions, and they don't realize, maybe it's the first time they've done it, but they don't realize that at closing they got to get out of there.
Oh yeah.
And then what do? I mean, then you have to work something out at the closing table to figure out when they're going to move out, and it becomes a mess. The other thing that I found a little bit troublesome, and I want to kind of send it out to your brokers out there, are situations where you have something similar to that, and then the buyer says, well, I'll lease you the property for the next 3 to 6 months. Okay, so you do a post-sale lease.
Right.
Like you said, these sellers are not ready to move on. They're not ready to move on now. They're not going to be ready to move on 3 to 6 months from now. It's going to be a messy situation. I always discourage brokers to enter into any post-sale lease of a property.
Agreed. It's almost as bad, if not worse, a pre-closing agreement.
A pre-closing lease.
Yeah. Let's go ahead and let the buyer in before they're the owner of the property.
Exactly.
So there's an issue there. Well, the scenario you just mentioned is advantageous to the buyer because at least they closed. They closed and they're the owner. Yeah, possession is 9/10, but an eviction can take care of that.
Right.
But that's not a pretty ending.
No, it's not. I mean, you're involving attorneys again. You're incurring litigation expenses. But the same thing. I mean, I think even worse when you have a buyer that's really interested in the property. The property may be vacant, and the seller says, "Why don't you just move in?" And start paying me rent up to the time of the closing.
Yeah.
Then you have a buyer with a mindset that, this is all I got to pay, and maybe I don't have to go to a closing. I can just keep paying this rent, and it causes all kinds of chaos in the end. You want to make sure that when you hit the closing table, that's the transfer of title takes place and the transfer of ownership takes place.
Agreed. And there's so many different hiccups.
Transfer of possession. The transfer of possession.
There's so many hiccups. I mean, on the surface, a lot of folks don't realize how hard a real estate agent works to pull a deal off because we're dealing with people's emotions as well as the biggest investment most will ever make. But there's a lot of ways that an agent can avoid these pitfalls just through communication. But you're representing a seller, and the seller says at the last minute, what, I'm going to end up keeping that refrigerator, or I know that we started off with these stainless steel ones, but I really want to take them to my next house. I want to replace them with all white ones. You just can't do that.
Right.
Yeah. And so I think that if agents would be just more direct with their customers, both buyers and sellers, and say, you can't do this. You have to be out by the day of closing because they want to do a walkthrough either the day before or the day of. And I just think that a lot of it comes back to lack of training. Lack of training and lack of experience is hurtful for the consumer.
Well, and also an ability to communicate. A lot of agents aren't able to communicate with their clients as to what can stay and what can go in connection with the property. And sometimes in the contract, they don't list properly what can stay or what's staying. And if it's a unique item,
Right.
you know, like a large side-by-side refrigerator or something like Sub-Zero refrigerator worth $10,000,
Right.
oh, you better put that in the agreement. You better specify it, not just refrigerator,
Right.
but Sub-Zero refrigerator,
Model
you know,
number,
and sometimes
serial number. Yeah.
yeah, you need to make sure that you specify that in the contract, and that kind of, you know, segues into what we were talking about in terms of what kind of things we need to put in the contract to make sure that the deal is clear
Yeah.
on its face
Right.
and it will go through. And that those are one of the issues that I always talk about is making sure you identify all the personal property that's being transferred.
Right.
Because if there's any doubt as to the personal property, or whether the drapes are being included, or whether outdoor furniture is being included, you better put it in the contract.
Well, you know, now we have the issue of all these TVs, these flat screen TVs, okay? So my understanding is it's attached to the wall, it's a fixture, right? Unless on the listing agreement it clearly states flat screen TVs are not staying, right? So if you come across any of those scenarios.
I haven't. I mean, on the flat screen TVs, I think that because the fact that the flat screens right now, unless you're talking about like a 70-something inch or an 80-inch, because they're so commonplace right now. I mean, they're worth like, you know, you can get a flat screen TV now for like $300. Yeah, people don't really push on that issue.
Right.
What they really push in is on outdoor furniture, because it
Okay.
says furniture. You know, outdoor furniture. They push on outdoor decorations. They also push for obviously the built-in cabinets and that sort of thing, where you have the seller saying, "Well, that's not really a built-in because I can kind of take it
Yeah.
with me." But in reality, it is. If it's attached to the wall and it's a built-in, and it's staying.
It's staying.
You know, but the TVs we haven't had a lot of issues with. It's more of the fixed furniture that we have issues
Okay.
with, and we've had some issues with clients replacing cabinets, kitchen cabinets, and like you say, putting in cabinets that are, you know, less expensive, or maybe putting
Well, I haven't
a
heard that
different
one.
top. Yeah,
They
because
changed the kitchen cabinets?
they've changed kitchen cabinets. And
That's a good one.
we've had litigation over that. We've had litigation with banks over that when we do like a short sale,
Right.
or a deed in lieu,
Yeah.
or a cash for keys type of scenario, where a bank will come in and take the property. But, you know, luckily a bank does a walkthrough before they
Right.
take the property, and they could see, because they use very wise property inspectors.
Right.
They can see what was there before, what wasn't there, based on, you know, what the dimensions are and that sort of thing. And they've called our clients out. And I go back to the clients and say, listen, were there granite countertops on top of these cabinets? And by the way, were these cabinets wood instead of Formica? So yeah, you got to be very careful what you do. But I think the way to take care of that is making sure that in the personal property section of the contract, you identify very clearly if there are any high price items that are staying.
Okay. Another question that was asked is the initial deposit on a purchase. So an initial deposit is not required to have a valid contract, but it's almost expected. You know, if you're representing the listing or the seller, of course you're going to, you know, state that you want earnest money. You want a good faith deposit.
Sure.
And the term we use a lot is the more skin in the game, the more committed that buyer is. Okay. The opposite side. When I teach agents, I always teach things from two perspectives. I go, you know, you're representing the buyer. You might think that going in with the least amount of deposit is a good thing, and it may not be a good thing, because it could come across as though they're not committed. They're not really prepared to make a decision on this property, and it could cost them the transaction.
Especially if it's a big deal.
Yeah.
If it's a big enough deal, you want to make sure that buyer and seller have their skin in the game, as you said. You know, they
Absolutely.
want to make sure that the buyer is putting up a significant deposit, and perhaps a second deposit.
There you go.
So that they can really make the deal, and they can go hard on the deal. And now at that point, both the seller and the buyer are committed. They're kind of past the point of no return, if
Yep.
you will, so that this deal is going forward. You want deals to close. As a broker, as an agent,
Mhm.
you want deals to close. I want to make sure your deals close. I advise agents in a way that allows them to get those deals to close. Not to litigation, but to close.
Mhm.
And a lot of things that we do in terms of making amendments to the contract and that sort of thing are geared towards making sure that we get a closed transaction.
Well, I'm glad you brought up the second deposit because I was just about to touch on that, and I don't think that's used often enough. So here's a scenario, right? You're coming in, and as the buyer, you say, I want to put $5,000 down deposit. Okay, the other side comes back and says, you know what? I really want you to put $15,000. Okay, how about this? Why don't we start off with the 5 with another 10 in 10 days? What can you accomplish in those 10 days? A lot. Most importantly, the inspection.
Right.
Okay, get through the inspection period because that's normally where a lot of deals are going to come to a screeching halt. It's going to be that issues are found in the inspection.
Inspection and also a better feel for whether or not you can get the right type of financing
That's true.
to get that purchase done. You don't want to put too much skin in the game
Right.
if you're not going to get the type of financing that you want. So, I mean, if you're given a little bit of time to spread out your deposit, that will give you a better feel for whether or not you're going to be able to pay what you want on that deal.
But here's the thing, because what I teach agents all the time is you better put certain things in red. The date for that initial deposit is important. If you got 3 days after the effective date, that is binding. Okay, if you have 10 days for the additional deposit, that's also binding.
Absolutely.
If the buyer does not deliver that second deposit, not only can they be in default, but the seller has the right to retain the initial deposit and the second deposit as well.
Yeah, because it doesn't, in the contract, it's not defined as a first or second deposit. It just makes reference to security deposit.
Yeah.
So you're putting at play all that deposit in there, and again, you want to make sure that that buyer has enough skin in the game if the deal starts going south, so you can kind of force them to say, okay, listen, you need to figure out a way to get financing on this deal because you've already passed your date to advise me regarding loan approval. So we're basically on a cash basis right now. You need to close.
Yeah.
So having a higher security deposit is always very important.
But it drives me nuts, Omar. It drives me nuts when agents treat these timelines as suggestions. Maybe this is South Florida and laws are only suggestions in South Florida, but last time I checked, the law is a law. A contract is a contract, it's binding. And so if you put down 10 days and it's day 11 and you haven't gotten around to putting that second deposit down, all it takes is for the other side to say, you know what, deal's off, you're in default, I'm keeping the initial and you owe me the second.
And that may be one of the things that you need to keep in mind, especially as a seller where you have a backup offer. Maybe you felt like you made this deal and you got a couple of offers after that.
Yep.
And this may be a real good way to back out of the deal.
Yeah, exactly.
So, I can tell you how many cases I've won and how many cases I've lost due to failing to meet certain deadlines by my clients or failing to meet certain deadlines by the other party. Deadlines are absolutely key in litigation.
Yeah.
And when you get into whether or not the other side filed the necessary documents by a certain amount of time, provided the loan approval by a certain amount of time, gave the right notification by a certain amount of time, then that's going to be the turning point of whether or not someone's going to keep that security deposit.
A question asked here is, what are some of the common mistakes that buyers make? Okay, and I think one of them, because we're on this theme right now, is not treating timelines as being important.
Exactly. Yeah.
Okay, and whatever your reason is, maybe they're 100% trusting in the real estate agent to know what they're doing, right? And the real estate agent isn't abiding by the timelines. But I cannot tell you how many times someone has said, a buyer says, well, that's not my fault. Doesn't matter, you signed the contract. Okay, the timelines are critical. So make sure that you as a buyer are on top of that agent all the time to say, what are my timelines? As a real estate agent, you write out these timelines in red and you say, we need this by this date, and this date.
Yeah, the first thing as an agent that you should do after a contract is signed and you have it locked in is an email should go out to that client and you need to put them on notice of when those deadlines are happening. And you need to tell them what the consequences of not complying with those deadlines are. If as an agent you are not notifying your client when those deadlines are happening, then you're creating at least a 50% chance that they're not going to comply with those deadlines. They're not going to comply with the loan approval deadlines. They're not going to comply with the notification of municipal lien deadlines. They're not going to comply with all the deadlines that are in a contract. And you need to be aware of what needs to be done within a certain time frame. They're not going to comply with the second deposit deadline. I think the second deposit is something that's absolutely key, even if it's a little bit more, but it mentally puts the buyer more tied into the transaction.
And it makes the seller feel better.
Right.
It makes the seller feel better, and then they could say, well, all right, well, we'll give you 7 days, or we'll give you 10 days, whatever. That can be negotiated. So, you know, the thing that buyers have to understand is in a seller's market, and for a large part in many of the price points out here, we're still in a seller's market. You have to, when you get an offer accepted, be blessed, be thankful, your offer is accepted. Now, I want you to think this way. Think that the seller, that very same day that they accepted your offer, got a much better offer right after.
Right.
And the person says, what can I do now? Yeah, what can I do now? Well, you can't do anything now because you're under contract. Well, is there anything I can do? Yeah, we can pay attention to all the timelines, and as soon as the buyer, you know, misses a timeline, and that seller may not want anything to do with your deposit, they just want to take the house away from you. Because they want to sell it to somebody else for $5,000 or $10,000 more. So it's inexcusable. I mean, go on record. It's inexcusable for a real estate agent to not pay attention to timelines and be in that situation where now your buyer is facing losing that home because someone said, "Oh, I screwed up." The inspection period is the inspection period. If you agree to 10 days, it's not 11. You know what? If you agree to 10 days and on day 9, you go ahead and say, here's a scenario. We want to have these issues addressed. If you don't include in that communication, and by the way, if these issues are not agreed to or resolved by tomorrow, consider this to be a cancellation, you have drawn it out. Oh, but we entered into negotiations. That's not what the contract says. The contract says you have X number of days to either go forward or cancel.
Yeah, and you know, a lot of people think that just because the contract suggests 15 days for the inspection period, that it has to be 15 days. I mean, that's negotiable. So if you feel as a buyer coming in that you're going to need more time to inspect whether or not there's mold behind the walls, to inspect whether or not you have issues with the roof, well then request 20 days, 25 days.
Or an addendum, have an addendum that says, you know what, we need more time, we found some issues, and we need the entire inspection period to be backed up by another 5 or 10 days.
Right.
But it's got to be in writing, folks. I mean, you can't go ahead and say, hey, I talked to them. And here's a scenario. So I go ahead and I send an email to the listing agent, and I say, we need an additional 10 days. I drop the ball and I don't do an addendum, but the agent responds back and says, no problem, you got the additional 10 days. Is that email communication binding?
Nope. Absolutely not.
Okay.
Just the email communications going back, and that's a lot of people think. Just if we exchange emails, and that's good enough. It's a suggestion that person is in accord with what you're recommending, but is it binding on the actual parties to the contract? I don't think so.
Yeah.
And courts basically have said that's basically an offer to agree. And when you say, okay, that sounds fine, you're basically agreeing to that suggestion, but it doesn't bind the parties. So you have to do a formal counteroffer, and you have to submit a formal addendum to the contract in order for it to be binding on the parties. Remember, a real estate agent is not an attorney, so you can't be in the person of your client. You represent your client and you make suggestions on behalf of your client, but you can't bind your client. Not in the same way as maybe like an attorney would bind.
Or maybe if they're acting as a single agent, but most real estate agents are operating as a transaction broker.
Correct. Yeah.
So you're not binding your client, which is a term that's often confused. I mean, 98% of real estate agents are acting as transaction brokers. You can't refer to them as your client; they're your customer. The client-agent relationship refers to a single agency. That's about the only thing I remember from school. Anyway, but but that's super important. I think we get lazy in this business, and
email does that. I mean, when we go back and forth with emails,
we agreed. No, we didn't agree.
No, I mean you can. I mean, when you have emails from if for example, if you have a situation where in a contract the buyer and the seller are being represented by counsel,
right,
and then you have an interchange between counsel that can be binding on the client, then yes.
What if the seller wrote back and the seller says, I'm okay with giving you guys 10 more days?
Well, but from whom is the communication coming from? Mm-hmm. Is it coming from the buyer? Is it coming from the buyer's attorney? Or is it coming from the agent?
Right.
If it's just an offer from the agent, then a buyer accepting or a seller accepting it is not enough until you sign that addendum.
Gotcha.
And it's just, listen, My goal and the way that I do my seminars is I try to avoid litigation.
Right.
I've been involved in enough litigation to know that it can be very costly, very time consuming, very stressful. I've had people during litigation go to the hospital because they're having like a heart attack.
Yeah,
litigation can be
anxiety.
very expensive, and what we want to try to do is we want to try to avoid that. And by putting an addendum, by clarifying, I say it's making the implied express.
There you go.
Okay, so yeah, when you have that email exchange, it's implied
Right,
that there's
right.
an acceptance, but until the addendum's signed, it's not made express.
Would you agree? And I'm a big advocate that addendums should be short and sweet. You know, a lot of times people get into all this, flowery words, and whatever's on that addendum overrides the contract. So if you're not careful, you can do more harm than good. If the name of the game is buyer and seller are both agreed to extend the inspection period until said date, that's it.
Keep it
All
simple.
other terms and conditions remain the same.
Keep
That's
it
it.
simple. That's it. You keep it simple, especially in an addendum that only deals with one limited issue. You want to keep it as simple as possible. Make sure you get it signed as quickly as possible, so that there's no doubt that both parties are on board with it.
Right.
And because listen, you can get an email back from a buyer saying, "Yeah, I'm okay with it," and then the buyer says, "You know what? I was under heavy medication when I sent that email," and all of a sudden it's not binding.
Yep.
Because he has to have the ability and authority to execute
Gotcha.
that, to give you that authority. But if the agent can say the same thing too, the agent can send an email back saying, my client's in agreement to it. Oh, he sent that back when he was partying out on South Beach and he was drunk.
Never
so
happens.
he didn't have the ability
Yeah.
to bind his client. So
Get it
it's
in
always
writing.
important to get it in writing. Make the implied express. Write that down. If you're listening to this, make the implied express.
Beautiful. So a question here on our Facebook page is, typically, how long can a probate process take?
Well, it depends on the complexity of the probate estate.
If it's
I mean,
uncontested or...
Yeah, if it's an uncontested probate estate and you're dealing with minimal assets, maybe 1 or 2 properties, that can be done in about 2 to 3 months.
Okay.
If you're doing with a more complicated probate, well, I've been involved in probate cases that lasted 3 to 5 years. So if it's contested, if you have multiple heirs and you have multiple assets, it can take a very long period of time. The key is to find a good probate attorney too. I mean,
Yeah.
someone who has a lot of experience in that area. I happen to work with someone in Davie that's probably one of the best probate attorneys.
Okay.
He actually teaches at the University of Miami. If any of you are interested in having access to a very good probate attorney, reach out to me, contact me so that I can send you his information. He's actually my probate attorney too, so I use him for all my wills, trusts, estates, everything
Great.
that I do. I use him, and he's right here local in Davie.
But question that our agents will have is, can the property go under contract while it's in probate? Absolutely. But you have to have a knowledgeable buyer that realizes you cannot close until the probate is completed.
Exactly.
So it may be advantageous to a buyer to know that they have that property locked up, but it can't be a buyer that's expecting to move in the next 30 or 45 days either. So it has to be the right
Right,
buyer.
until there's a court order or there's an indication from the court that the person that's the heir or the administrator now has the right to transfer title to that property. Until that happens, they can't close. They can go to a closing, but they can sign all kinds of stuff,
Yeah.
but it's not going to be valid.
Gotcha.
So until there's a determination from the court that they have the authority, either as an administrator of the estate or some other form. I'm not a probate attorney, so
Right.
I'm not too familiar with that, but until that's done, they can't transfer title to the estate.
Next question, and it deals with potential crossing of the lines. Let's say an agent is working with someone from a foreign country. Let's say the consumer, the customer is Spanish speaking, and the agent takes it upon themselves to translate certain items into English. Does a possibility exist that the agent has now practiced law by doing something like that?
Well, I don't think that they've practiced law, but you're now opening up the possibility of that potential client coming after you because he misunderstood the contract. You're running the possibility that the deal can go south because that potential buyer said, no, I was under the understanding that this was going to happen based on what the agent told me. How do we fix that? We have Spanish versions of all of our as-is contracts that we can provide agents. And if there's any doubt regarding what's put on that contract, you need to provide that client a Spanish version of the contract they just signed.
But I'm glad you brought that up. The Spanish version is available for educational purposes, but it's not what's used in the transaction.
Yeah, but and then at that point you need to say, listen, this is what we have.
Right.
If you have any questions, you need to talk to an attorney.
Right.
If you have any questions regarding your rights and don't understand it, even after reading the Spanish version, you need to contact an attorney. But by no means, and I know the agent, listen, there's a lot of agents out there and they have a helper's heart and they want to serve and help that particular client and they want to try to help them. But listen, we're living in a litigious society and they say that no good deed goes unpunished.
Yes.
So you got to be very careful when you're giving that kind of advice to clients because they may misunderstand it, they may not agree with it, and they may hear something that's different from what you're telling them. So once you give them the educational version
right.
of the as-is contract that's in Spanish, you tell them, listen, this is all I have. I can't. I'm not a certified translator,
right?
So I can't translate exactly what this means. But this is what I have. If you have any questions, you need to contact an attorney.
We need to get that for our use here, I think, and you're making it available to the audience as well that wants to get that, right? So at the end of the broadcast, we're going to give all of our contact numbers and everything. So how about this? An agent's working in a short sale scenario. The agent takes it upon themselves to write the hardship letter for the seller. Okay, they're practicing law now?
If they're not practicing law, they're coming very close to it because now they're stepping into the shoes
right.
of the seller. Now, we always tell is have the seller prepare
right.
whatever they need to prepare as a hardship letter,
right.
and then we'll sort of embellish it to make sure that it's read properly. I mean, some people are not the best writers in the world,
yeah.
so they'll send us the hardship letter, but it's theirs. It's their work product. All we're
right.
doing is basically making it more appealing and more acceptable to the underwriters that are reviewing it.
But you can do that as an attorney. For an agent to embellish and take that to another level is probably not a good thing.
You know how I feel about that. I mean,
right.
as far as agents are concerned, when you're doing a short sale, I really do believe and strongly recommend that agents reach out to a law firm that specializes in doing short sales, because a lot of these short sales are in the middle of a foreclosure process, and before you know it, the property is sold at a foreclosure auction. So I want to make sure that agents out there are familiar with the concept of the fact that even if you're in the middle of a short sale, that does not automatically mean that a foreclosure sale is going to be stopped. It does not automatically mean that a sale is going to be canceled. It just gives you an avenue to suggest to the court why the sale should be canceled, but the court can say no.
Yeah, they can say
you
no.
have higher counties that have a lot of volume of foreclosure cases, and they'll give you only 1 or 2 chances to cancel a sale, and after that, you're done. And they don't care. They don't care about the fact that you're processing a short sale. The first thing they'll ask you is, when's it closing? Is it approved?
Yeah.
Is it approved, and when is it closing? If you can't answer those 2 questions for the judge, and the sale has already been canceled several times, chances are very likely that the sale is not going to be canceled again. So be sure that if you're running a short sale, if you're processing a short sale, you reach out to people who do this on a regular basis. I mean, agents don't make any more or any less by underwriting a short sale.
Yeah, the bank is not going to pay you anyway.
Right.
But you bring up a good point, and as we're starting to run down on time, you know, as much as we want to help people by offering them a short sale, not everybody wants to be helped. You know, and I just came across this week. We have a scenario where someone filed for bankruptcy. Okay, and I asked you that question. They filed Chapter 13, right. And it was discharged. So the owner is under no obligation under that debt anymore
to pay the debt.
Pay the debt, and I'm trying to urge that owner to at least consider a short sale. Right? And he's like, well, what's in it for me? And I said, well, how about buying you more time? If we're successful at getting the sale date pushed back, maybe you can gain another 60 to 90 days. The person says, I don't care about time. I have a place to live. Okay. I pull out another arrow and I says, how about avoiding foreclosure on your record? You already have a bankruptcy, which is going to be there 7 to 10 years.
Yeah.
Do you want the Twin Towers of the worst thing that can happen there? You want also a foreclosure? Oh, I don't care.
Yeah, my credit's already ruined.
Yeah.
I don't care. How about the fact that you may want to buy a property sometime within the next millennium?
Yeah.
You may want to buy a property within the next 2 or 3 years. The only way you're going to do that is if you do a short sale. Listen, banks want the short sale process to go through. I have a lot of clients that say, oh, I've tried a short sale 3 or 4 times. The bank has never approved it. I had that situation with a client where just before I came here today, he tried a short sale 3 times on his own. They denied both times, all 3 times. And I asked them why. Is it because the bank were asking too much money? Well, how do they know what kind of money they're asking for? Well, they had a guy do a drive-by, and they. But we have roof problems. We have all kinds of problems inside the house. Well, did you have a GC do a home inspection to find out how much it's going to cost to fix the roof?
Right.
Did you have your own appraiser go out there and find out how much the actual value of that house is, and not just the market value of that house is compared to every other house that's in good condition in the area? So those are techniques that we use to make sure that the short sale offer is approved by the bank and is accepted by the bank, instead of a much higher price that doesn't make any sense to any buyer.
Well, it sounds like you do a lot of what the real estate agent is supposed to do. Like for me, based on my training, an agent's supposed to be doing all that, supposed to know all that. But you've learned the hard way that a lot of the agents out there are not well trained in that area. So you're having to step into the shoes and say, listen, if we want this short sale to be approved, we got to make a viable argument. You can't make a viable argument based on nothing.
You're putting forward the best evidence you have.
Right.
That's what it's all about. And it's not about going to law school. It's putting in the hands of the bank something so that they can justify to their superior when that file gets audited why we accepted 150 instead of 210.
Exactly.
Okay, so you need to provide them their justification. They're not being difficult with you asking the higher price. It's just what they have in front of them.
It's not even the bank's money. The banks usually are just servicers in these scenarios.
Right.
They're representing either Freddie Mac, Fannie Mae, private investors, and they have guidelines that they have to follow. So I always tell people, look, if you ever loan somebody money, you expected to pay them back. Well, that's kind of how the bank feels. Okay? So look, I think I'm getting the signal that we are done. The beautiful thing about Facebook is we can let's just keep going. Nah, maybe not. We'll save some for the next show.
For the next show.
So go ahead and tell them how they can reach you.
Well, listen, I would love to speak to everyone. Personally, I speak to everyone. I meet with everyone face to face. I believe in that. I believe strongly that whenever you're seeking legal advice, you deserve at a bare minimum to meet with the attorney and not just, pick up someone on the phone or speak to an assistant or a paralegal or someone like that. You need to speak to the attorney. If you call a real estate attorney and they put you in contact with their paralegal to meet with or an assistant that doesn't have a lot of legal knowledge, then you should kind of pass on that and go to the next person. That's why we have a very strong philosophy at the Arcia Law Firm that I meet personally with all the clients that come to my office. The best way to reach me is by calling us, 954-437-9066. 954-437-9066. You can also go on our website, which is arcialawfirm.com, ARCIA lawfirm.com. And finally, you can contact us via email, info at arcialawfirm.com, and your email will be responded to very, very quickly. And if you need an appointment with us, we'll make that very quickly as well. I mean, we enjoy this process that we're undertaking right now, and we're looking forward to many more shows and providing you with much more information. But in the meantime, if you need more personalized knowledge or personalized information, either for you or for your clients, give us a call, 954-437-9066.
Okay, from our end, anything that regarding real estate, if you're looking to purchase, to sell, to invest, to rent, if you're a real estate agent in search of a home, you're looking for an office that can provide you with the training, the support to get you to where you need to be, we would love an opportunity to share our vision with you. We have over 135 professionals. We cover a lot of territory, but we treat every single customer on a one-on-one basis. So there's our website address, Extreme with an X, realtyteam.com. Call our main office in Davie, 954-530-0211. That's 954-530-0211. Once again, I'm Tony Martinez, broker for Extreme. Omar Arcia of Arcia Law Group, Law Firm.
Yep.
I'll get that right. And listen, this has been great. Third show in the can, and I'm looking forward. So spread the word. Wednesdays from noon to 1 p.m. Eastern. We'll catch you next week. Thanks, Facebook. Take care.